Well, welcome everyone. Thank you so much for joining us for today's Appraisal Buzzcast. We've been getting so many new listeners and we really appreciate all your support. If you aren't already subscribed, please take just a second to click the subscribe button to make sure you get notified of our latest Buzzcast every week. We have a special one today, folks. Joan Trice, CEO of Allterra Group, will be interviewing Jeremy Bagott, appraiser, and Dennis Scardilli, attorney in MAI, and we will be talking about USPAP. But I promise you this will not be boring. Joan, take it away.
Thank you, Jim, and welcome Jeremy and Dennis. And, I hope we didn't lose our audience just at the mention that we're going to talk about USPAP today. But I promise the audience that this is really going to be worth a listen. And these are two very interesting guests who are embarking on some unique paths for appraisers. So I'm going to start out here with Jeremy. And Jeremy, I understand you have a petition in the state of California. Why don't you tell the audience a little bit about that?
Sure. Thanks for having me on, Joan, and thank you for the great introduction, Jim. Well, in April, in the darkest moment of the pandemic, I put together a petition to the California Office of Administrative Law. And there's a problem in California with state administrators, state agencies enforcing laws that haven't been properly crafted or properly put through an administrative process. In this case, a process called a notice and comment rulemaking. And that is, it expedites matters if you don't do this. But when it's discovered, it's called an underground regulation. And that's what I believe USPAP is in California. And so what I did is I filed a petition with the Office of Administrative Law. The Office of Administrative Law is kind of unique. I couldn't find any other state that had a dedicated page to this kind of extra legal regulation. And so the problem is such in California that the Office of Administrative Law has essentially a snitch line that you can contact them. They'll help you with, they have a petition template to try to get state agencies, in the case where they're enforcing so-called underground regulations, to come into compliance. And in the case of USPAP, the compliance would be a notice and comment rulemaking for each version of the USPAP. So for example, the 2020-2021 Uniform Standards of Professional Appraisal Practice would have to be put through a notice and comment period in which members of the public, and it might not be simply appraisers, it could also be mortgagors and investors in land secured bonds. And it could be people involved in tax assessments and things like that. They can go on record and talk about what they disagree with in the current version of the uniform standards. What they can simply go on record, for example, are the standards being changed too frequently?
So to summarize, USPAP is out there and there's been no process for public comments, or?
Yes, yeah. Dennis was going to explain the difference between a statute and a regulation, and that's key to understand. For anyone to understand what's going on here and where the deficiency is, they need to understand that difference between a statute on the legislative side and a regulation on the executive branch side. So
all right.
As the provider of innovative appraisal solutions for more than 40 years, ACI is a trusted industry leader. Join the thousands of appraisers in many of the largest appraisal companies that use ACI software in the US and Canada to optimize their business. The ACI One individual plan is available today for $649 and includes forms and rules, sketch software, unlimited location and flood maps, public record data, ACI Open House, and more. For more information, visit aciweb.com.
And then one more question. Is this challenge to USPAP and the way it's, for lack of a better word, promulgated, is this challenge transferable to other states?
Yes. What I found in researching my book, Dispatches from the Cosmic Cobra Breeding Farm, last year, it is indeed a problem in other states. I found it in Texas, in Washington State, in New Mexico, South Carolina, but I also found states that are following their respective administrative procedure acts, like Kansas, Kentucky, Michigan, Maine. So it's not across the board, but it is a problem. And I think the USPAP's 2-year change cycle relies on this, that if you had states that were following their own administrative procedure statutes respective to USPAP, there would be back pressure. They wouldn't be able to do it in many cases. For example, with California, it's not the note, from what I have it on good authority, I'll put it that way, that it's not the notice and comment process that can take 2 years or more. It's the sign-offs at the Department of Finance, the Secretary of State's office. It requires, for example, rulemaking would require a cost-benefit analysis to be done at the California Department of Finance. Someone who would look at it for impacts to small business. How does this change that you're now promulgating? How does this affect small business? And there are many other elements that are done and also another thing is if an attorney 2 or 3 levels up makes a single line out to the promulgated regulation that goes all the way back to the Bureau of Real Estate Appraisers. So they have to start from the beginning. So they can't reliably do it in 2 years, so they don't do it. And they hope you don't notice.
And what is it you're trying to accomplish here, Jeremy? I mean, is it that the 2-year cycle is just unnecessary and doesn't benefit the public trust nor the appraisal profession in these constant turnover?
Okay, my heart of hearts, yes, I'd like to see that happen, but I'm going to spot you. I'm going to spot you that the 2-year change cycle is okay. I want to see my state follow a statute, the state's administrative procedure statute, and see if it can even be done.
Interesting.
In a broader sense, I would like to see that 2-year change cycle change to 3, 4, or 5 years. I think the 2-year change cycle has much more to do with the business model of the appraisal foundation and less to do with the need to change it every 2 years. And remember, small business, and that's what we are. Most appraisers, it's a mom and pop business. And it relies on 2 things. It relies on predictability and the rule of law. And, you know, we can't thrive without both of those things. And I think we're getting neither of them here in the state of California.
From that current process. Okay. Well, then let me ask Dennis for a moment. Dennis, you've got a legal challenge of your own in New Jersey. And by the way, let me just caution everybody that neither gentleman today is offering legal advice. And I'm sure Dennis is going to reiterate that. So Dennis, share with us, please.
I first want to make it clear at the front end here that I'm not providing legal advice, as Joan just correctly said. I'm merely offering comments on the state of the law on a thorny issue that actually emanated from a U.S. Supreme Court case in 2015, and the court has been paying more attention to these issues. So let me also say, before I proceed, that I read Jeremy's book about a year ago, and I was very impressed with the research that Jeremy had done. It's a fascinating book. If people out there haven't read it, shameless plug for Jeremy's book. I would suggest to read it. Before I proceed going forward, let me back up for a moment briefly in regard to Jeremy's comments about the 2-year cycle. I helped draft the New Jersey Appraiser Management Company Act, has been doing work for some real estate appraisal organizations. And I went to a board meeting at the time when they were adopting the regulation, and my esteemed colleague, and I mean that seriously, who was the board counsel, said to me, don't bring me 12 appraisal management cases next month, because it's going to take at least a year to get this through the process. And I said, year? But the statute was supposed to be effective when it was adopted. He said, don't bring me in. Well, she was wrong. It took 2 years. So the point is that I've been at 4 levels of government. And the issue that Jeremy brought up in terms of the 2-year cycle is, I think, at the heart of the issue that we're discussing today, which is there's a disconnect between the governmental process that takes place in every state and the USPAP cycle that needs to be addressed. I'm not saying how it should be addressed, but Jeremy has a lot of insight into that. Joan, I'm sure you've testified Congress, you've testified for the Standards Board. Joan, you know all about this, I'm sure. Let me go forward a little bit, if I may, with regard to what I wanted to put on the table here, which is that there's a relationship also that's very important between the U.S. Constitution and real estate appraisal. And I think that is something that is certainly not taught in the 7-hour update. And I'm an appraisal standards instructor, and as you know, appraisal, the 7-hour update is pretty much standardized in terms of what it would say. Now, also, I want to narrow this a little bit because the case that I'm handling as part of the legal team in the Federal District of New Jersey, and also the underlying disciplinary case before the Office of Administrative Law, New Jersey, is a non-FRT case. So,
Now, wait a minute. You better define for the audience what an FRT is.
Yes. An FRT is a federally related transaction. I don't have the language in front of me at the moment, but the FRT is when the transaction, when the loan is going to go through a federally regulated financial institution.
Correct.
Which, the list of which are set forth by RIA statute and should be in a number of the textbooks. I'm sure that they're in the 15th edition.
And we could spend an entire 30-minute podcast on just a discussion of federally related transactions and what impact that has had on regulation. And we should do that. So, hey, Jim, make a note of that. Back to you. Sorry to interrupt.
Oh, I'm sorry. I think that's one of the issues you testified on. So this was a non-FRT case, a non-FRT appraisal. What I want to do is I want to walk the listeners and the viewers through the process so that you know what leads up to that letter you don't want to get from the appraiser board.
Right.
Okay. So if there's too much there, or if you're trying to make a living and you're not an academic, there's too much there for you to read. I'll just summarize it for you. It deals with constitutional issues, specifically the 5th and 14th Amendments of the U.S. Constitution, which deal with due process, and also the New Jersey Constitution, which deals with similar issues. Again, if we don't have enough time to go into the 5th and the 14th, as Joan said, we could have a whole podcast on either one of them. So in regards to the other issue. So with FRTs, there is a separate legal analysis. But with non-FRTs, as in this case, we're dealing with state law. So with an FRT, we're dealing with federal law. With a non-FRT, we're dealing with state law. So let's talk about how do you get to that point of how did USPAP become law? People may ask. What are you talking about? Well, we're talking about USPAP here, and you're getting into law. Well, USPAP has been adopted by many states as law by reference, by incorporating it into the statute. How did that happen? So we have a legislative branch that makes law, and they're supposed to make the law. So in New Jersey, for example, in 1991, the legislature adopted the New Jersey Appraisal, and most of the other states did so sometime between 1990 and 2002. The executive branch, the governor's office, the AG, the Attorney General's office, the appraiser board implement the law. The judicial branch, such as the Office of Administrative Law, the Superior Court, appellate courts, Supreme Courts of various states, interpret the law. So the legislature adopted the New Jersey Appraiser Act and they reference USPAP in 1990. So the statute creates this box. And within the box, the legislature said to the executive branch, okay, you fill in the details within the box. Those are called regulations. And then the regulations then adopt standards to convert the line item details into the application of the law. So you have these, follow the dots there. So we have the statute, we have the regulations, then we have the standard. The statutes also include the appointment of the board, authorization of the agency, powers of the board, et cetera, and adoption of USPAP by reference. So in New Jersey, the statute, and in many other states, and I just wrote, shameless plug for myself, I wrote a chapter for LexisNexis on valuation law in California, and California has somewhat similar procedure. So we have the we have the law, we have the regulation, and then we also have some other stuff kind of off to the side. And the other stuff is called the Administrative Procedures Act in a state, just like at the federal level, we have an Administrative Procedures Act. New Jersey has a law called the Uniform Enforcement Act as well, but sometimes those are blended together in a state. So what happens is when a board says, okay, we're going to adopt USPAP as our standard, what they do is they publish in what's effectively called the newspaper of the state of New Jersey, just like the Federal Register is the newspaper of the federal government. They publish, we're going to adopt a rule. That's what Jeremy's petition is addressing to a certain extent. Here in New Jersey, what they did was they adopted the rule, and different states have different sunsets for these rules. Some have none, apparently, some have very short. New Jersey had a 5-year, they extended it to 7. So New Jersey adopted USPAP in 1991, and then.
But wait a minute, did they adopt it in perpetuity, just saying we adopt USPAP in whatever standard it is at the time? Or did they say we adopt the 1990 version of USPAP?
Joan, I wish you were on the New Jersey District Court.
Oh, thank you.
That is the question.
I have watched Boston Legal from time to time.
Well, that's part of a legal education. That is the question that the judge will raise in this case. So the statute just says that they're adopting USPAP. So the legal question that comes up is the one you just raised. Now, when the state of New Jersey, through the board adopted USPAP in the 1991 rulemaking procedure. They use the word current.
They use the word what?
Current.
Okay.
As in present.
Okay.
So the question then becomes, what did they mean? In 1996, when the board readopted USPAP, they used a phrase, then currently in effect, or words to that, similar words to it, trying to clarify that we're current. In other words, trying to answer the correct question you just raised. In New Jersey, the issue, as in many states, the issue was just incredibly well described in Jeremy's book. And that's the one you just succinctly raised in this podcast. Well, what do you mean? Do you mean you're adopting any changes that anybody might make to USPAP? So the question then becomes, well, yeah, the board might say. We're going to use the current version because that's what the 91 regs that we adopted said. And then we cleaned it up a little bit in 96, 97, when we said then currently in effect. And oh yeah, by the way, in 2002, we said the same thing. So, and then I think it was in 2007, I believe, that they readopted, and then they readopted again in 14 after it was changed to 7 years. So let's go back to what we were talking about a moment ago. Who creates law? Well, the legislature creates law. The executive branch implements law. The judiciary interprets the law. So Joan's question is the question that a judge would ask, which is, what are you guys talking about? And that's pretty much the crux of the New Jersey case.
Interesting.
Appraisers, if you've grown frustrated with endlessly pursuing new appraisal work and not reaping any of the benefits, Metro West is here to help. They understand and work to alleviate the pain points commonly felt by appraisers to enable personal and financial growth for their staff. After all, they've been owned and operated by appraisers since the company opened in 1987. Metro West Appraisal is an equal opportunity employer, and they're always looking for certified residential real estate appraisers to join their team. Visit metrowestappr.com/careers or email careers@metrowestappr.com.
So pardon the pun, but who's zooming who here? You know, accountability is one of my favorite principles. And I guess, Dennis, my question for you is, who's actually making the laws here? And it just almost seems like a lazy man's way to tackle this process. And I don't know, I'm a little confused. It just seems to me this process is horribly flawed. What are your thoughts on that?
Well, again, I think you should be on the bench, because I think that's a question the judge, at least in her own mind, perhaps not to state it on the record, but that would be the gist of the question from the bench. So let me answer you directly. Effectively, the ASB promulgates USPAP, as we know, not effective. According to everything that everyone knows, the ASB promulgates USPAP. Now, it's not unusual for private entities to create standards, and those standards be adopted by the executive branch, either at the federal level or at the state level. But the issue is how they're adopted. So when you have a change from, let's say, 2018 to 2019 to the 2021 USPAP, I would venture to say that in most states, ASB created the law, because the ASB made those changes. Most of the states have what Jeremy has, I think, beautifully described as a rolling incorporation by reference. And that change by the ASB has now become law. Does that answer the question?
Yeah, I'm actually going to invite Jeremy, because Jeremy looks like he's ready to pop out of his seat because he's probably frustrated. I'm not smart enough, guys, to even know the right questions to ask. So you two know more about this topic than probably anybody else cares to know. So Jeremy, I'm sure you've got some questions to Dennis. Why don't you fire away?
All right, but I feel a little bit like I'm stepping outside of the sacred, relation. I felt when I already did sort of I said, Dennis, what do you think? And I felt immediately like I stepped outside.
I'm giving you carte blanche permission to fire some tough questions at Dennis.
Order from the bench.
Okay.
Yeah,
Dennis,
exactly.
All right. Could you talk a little bit about how this might run this whole idea of a private group of individuals, none of whom have taken an oath to uphold the duties of any particular office in any particular state. This group of essentially private persons that are not known, for example, to my state, the state of California. How does this apply to did you say the 16th Amendment?
14th.
The 14th Amendment.
Well, it starts with the Fifth. The Fifth Amendment talks about due process. And then the 14th Amendment applies the Fifth effectively to the states. So, for example, if the ASB creates a regulation, it creates a provision in USPAP, and the state board applies the provision of USPAP without the state board going through the Administrative Procedures Act in New Jersey, or the petition process, the process in the petition you raised, then there's a question of whether that regulation is legally sufficient, whether it's been legally sufficiently adopted, and whether it has the color of law, as the lawyers would say, to try to charge for money. But anyway, the point is that this is not abnormal. Again, at the federal and at the state level, like, for example, drag race and environmental standards for testing and so forth are adopted by private organizations. And then they are adopted by the federal or state government, which is permissible under this due process provision. The issue that comes up is when, like you're saying in California, the state has not properly adopted that private standard, allowing the citizens who are being affected by it to have something to say at the state level. And that's what we're talking about in this New Jersey case.
Dennis, could that adoption that you speak of, could that also be called a notice and comment rulemaking? Is that what we're talking about?
Yes, that's effectively what we're talking about.
Well, let me ask a question here. It seems to me, if under your premise that the foundation, or excuse me, the AQB is writing law, does the foundation have in-house counsel?
I don't know that that's so relevant. I think if you said,
well, if you're writing law, wouldn't you expect a lawyer?
Well, if you said that the Kiwanis Club, or you said the Knights of Columbus, or some other fraternal organization was now going to be able to create a set of regulations that would be embedded into let's say a state's occupational licensing, does it really matter if you're saying we are going to outsource this governance itself to a group of private persons without any safeguards, without the safeguard of a notice and comment rulemaking, of an adoption, as Dennis put it? How relevant is it? What if they had 5 attorneys? What if they had 5 attorneys and a lobbyist and a priest? What if does it really matter if you say, we're going to outsource a set of standards to a hunting club? I don't think it really matters. I think that's kind of irrelevant.
Jeremy, I agree. I disagree with you, because I think it is relevant. I think what Joan is suggesting is, Joan, if I may rephrase your question for you.
Sure.
Take the liberty of that. I think what you're asking, is there any legal oversight in this process?
Thank you. Yes, better phrased. Yes.
And no, but that's what you meant, starting with the ASB. The TAF has an outside counsel, to the best of my knowledge. But I think that the issue becomes whether those regulations, whether they're created by the ASB, or they're created for drag racing, or they're created for environmental training issues, or whatever, that those regulations and those standards rather need to be vetted and have oversight by a governmental entity if they're going to become law. Now, I have the highest regard for the folks at the ASC, at the appraisal subcommittee, for Jim Park and Alice Ritter and the staff there, Denise Graves, they're just great.
Yep. Amen.
The question is, well, at the federal level, is anybody overseeing this? And the historical practice of the ASC is, that's not in the statute. That's not in FIREA, so it's not our responsibility. Then what happens is, then you get to so again, we're talking about a non-FRT. We're in the non-FRT silo. So in the non-FRT silo, then this USPAP standard goes to the state board. And the state boards have an affirmative responsibility to give it some thought, and not just rubber stamp it or just ignore it, as Jeremy is alleging in California. The legal oversight then goes to the state board, and the state board has this. They can't just say, "Oh, ASB told us to do this," we're going to do it on a non-FRT.
Well,
there's-
I was getting ready to pull that thread through, and
Go
I'm
ahead.
so glad you've come back there because that's where you started. And I know there's been some questions, and I apologize to the audience. This is such a dense but incredibly important topic. The question is, do the state appraisal agencies have the authority to sanction anyone for a violation if it's a non-federally related transaction? Is that the
That's
gist
what
of your case?
I should say it depends. That's the answer they told us to give in law school. So,
And you can
So-
rephrase my question if I didn't ask it right, but
no, I
you
did
get
ask
my
it.
point. I mean, there's been a lot of discussions that the state regulators don't have the authority to enforce any disciplinary action if it's not federally regulated.
Well, it depends on the states, on the underlying state.
The way they're drafted. Okay.
So if the underlying state regulatory statute, like New Jersey, which was amended in 1997, 98, was actually applies USPAP to any appraisal.
Okay.
Drilling down on that.
But that varies from state to state.
Varies from state to state. Some states, the ASC used to categorize as FRT only, mandatory, which New Jersey's mandatory. California is theoretically FRT only, but that's what my whole chapter for Let's Next
Yeah.
dealt with, so we can't go into that.
Yep.
But so if the statute says that the standard for the regulatory standard is USPAP for any appraisal as it states in New Jersey, then the state board utilizes USPAP. The next step is the question that you just raised as to whether the ASC has the legal authority to supervise the board's regulation of a non-FRT in a mandatory state.
Okay. Okay.
I think I can answer that in California. In
Okay.
California, the Office of Administrative Law, in its description of an underground regulation, simply says that if an underground regulation is found to be in existence and being enforced, it will be made unenforceable. It's an underground regulation. I have a question for Dennis, and that is, Dennis, do you believe that a regulation or a court order or a consent decree or an executive order from the president, for example, do you believe that that's simply a statute on training wheels? Or do you think that you believe that a regulation or a court order has every bit the weight of a statute?
I'll tell you what they told us in law school. It depends. When I was at HUD, we put together a guidance document for rent comparability study. And Jim Park was at the foundation. The position John Brennan was just in, and Lisa Tamara is in now. And we had conversations with Jim, we had conversations with other people, with people at Arrow. And the conclusion that we came to when we were designing a federal guidance document, not a regulation, but a federal guidance document, was we're not going to push, we're going to give the states some wiggle room in regard to whether they thought that a rent comparability study came under standards 1 and 2, or 3 and 4, which then were the consultation analysis section. So in a case like that, the conclusion was, we think that under the supremacy doctrine, that a federal guidance document is more, would come before a state law in regard to whether you use 1 and 2 or 3 and 4, but we felt it wasn't worth pushing. So again, it depends.
Gentlemen, I think we're running out of time, but here's what I would like you all to promise the audience is, Jeremy, keep in touch. Let us know. We'll come back, bring you back
I will do that.
later down the road, and so that we can touch base and find out what the status of your petition is. And Dennis, the same offer to you. We want you back so that we can discuss the outcome of your legal case as well. So, gentlemen, thank you very much.
Thank you.
And,
Thanks, Jim.
very
Thanks, Jim.
interesting conversation today.
In uncertain times, you need a certain partner. You don't have to sacrifice top-notch coverage for an affordable premium. Intercorp has all the options and is sure to have just the right one to fit your specific needs. They provide the appraisal profession with competitive, best-in-class E&O coverage solutions nationwide. Having served the insurance needs of the industry for more than 25 years, Intercorp understands the risks you face every day. Whether you're an individual appraiser, appraisal firm, residential, commercial, or an AMC, visit intercorpinc.net to get a competitive quote today. Well, thank you so much, Joan, Jeremy, and Dennis. That was really an enlightening discussion on USPAP and everything that's going on behind the scenes. We'll definitely hear more from you on the conclusion of the petition and the case, and after we see what happens. Appraisers, if you want to make sure that you're getting our latest buzz as soon as it's posted, make sure to subscribe. Have a great day.